Good morning, fellow humanists. My name is Todd Kimball. I'll be your MC today. It's an honor to be with you. We've got an exciting presentation today that I know is going to benefit a lot of us here this morning. And humanists believe that the ultimate goal should be the fulfillment of the potential for growth in each human personality, not for the favored few, but for all of humankind. Humanists urge the use of reason and compassion to produce the kind of world we want, a world in which peace, prosperity, freedom, and happiness are widely shared. Our reader today is one of the original founders of the Humanist of Greater Portland, Mr. Del Allen. Please welcome Del with our reading today.
The reading today is from the Dalai Lama. The Dalai Lama, when asked what surprised him most about humanity, his answer, man, because he sacrifices his health in order to make money. Then he sacrifices money to recuperate his health. And then he is so anxious about the future that he does not enjoy the present. The result being that he does not live in the present or the future. He lives as if he is never going to die. And then he dies having never really lived.
We are in the demographic to benefit immediately today from what Garvin Reiter is presenting. He has spent his career educating and helping people with the legal aspects of aging. Mr. Reiter prepared himself for the weirdness of Portland early in life as he was raised by hippies in a commune in West Virginia. Mr. Reiter was educated locally, earning his BA from Reed College and his law degree from Lewis and Clark. He is a certified elder law attorney for Ney Friedenberg. Garvin has been recognized by the National Elder Law Foundation as a certified elder law attorney. He has extensive knowledge of all options available to elders, including how to pay for long-term care without depleting assets.
So we're going to talk about basics of estate planning, a little bit of an elder law focus because I understand there's not a lot of spring chickens in this group. And an elder law focus just kind of means that a little bit more of a focus on capacity issues, loss of capacity, and long-term care issues. We have agreed that we're going to do question and answer at the end of the presentation, not during, and I'm going to stick around a little bit for that. And but I'm going to talk till basically like 11, and then we'll open it up for some questions. So basics of estate planning are about really incapacity planning is kind of like the number one. Number two, planning for your death and how to deal with your estate and assets and things like that when you pass away. And number three, dealing with sort of a subsection of incapacity. Like there's incapacity planning, like what if I become incapacitated, and then there's what if you are incapacitated, or you need expensive help with things like getting out of bed, going to the bathroom, taking showers, Alzheimer's care, and that sort of thing. And how do you deal with that? How do you pay for that? That's plenty for an hour. And there's a lot of things on that list of sort of like estate planning and elder law that we don't have time to do for an hour, like taxes, but that'll be another talk for another day. So let's start by talking about planning for incapacity. So incapacity means the inability to manage the basics of health and safety due to a cognitive impairment. I mean, that's kind of like the standard definition. So we're talking about 90% of the time a significant cognitive impairment. Incapacity can also be somebody who is completely capacitated, but mentally and understands and doesn't really have a cognitive impairment, but has a communication deficit that's severe enough that there's no way around it. That would also be considered incapacity under the law. There's incapacity the way that like doctors would think about it, which is the ability to give informed consent to medical treatment and to understand enough about your medical needs to be able to process those, indicate that you understand, and make decisions. Lawyers look at incapacity as more of a transactional type of a concept, meaning, what's the transaction? Well, I want to sign a will. I want to sell my house. I want to sign a power of attorney. I want to enter into a contract. Lawyers will talk about incapacity as the ability to understand the nuts and bolts of that transaction at the time that you're entering into that transaction. That latter part is pretty important because there are people that have kind of like ups and downs with incapacity. Incapacity can go in cycles. There are times when people have periods, windows of lucidity. There's such a thing as sundowners for people with Alzheimer's, where they're pretty good in the morning and then in the afternoon not so good. So there are people even that have not severe Alzheimer's or severe dementia, but moderate, who would be considered legally capacitated in the legal setting, because at the time they're entering into a transaction, they do understand it. But that's tricky, and we could talk a lot about that. The idea behind planning for incapacity is to do it before there are really any questions about your ability to process information, so that if you reach that point, your goal is that you have the right people in place to handle your financial matters and your healthcare matters, and to wind things down when you die. That's sort of the third thing. That's not so much about lifetime incapacity, but dealing with your financial matters and healthcare matters in the event of loss of incapacity. That's the deal. So what about marriage? Does marriage do that? And no, the answer is no. So just getting married does not give your spouse the authority to sign for you on a deed to convey title of your home. It does not give your spouse the authority to write a check on a bank account in your name. So signing authority does not come along with marriage. To a more substantial degree, as a sort of an informal way, marriage usually is recognized in terms of medical decision making. So if you don't have a formal document appointing a medical decision maker, which in Oregon is called the advance directive, it's pretty likely that your spouse is going to be able to direct your care if you've got full-blown Alzheimer's, or you're in a coma or just unconscious, whatever. But that's not actually legally enshrined under Oregon law. Most states do have provisions like that, but Oregon does not. Oregon does recognize the authority of a spouse to make decisions about end-of-life care. So if you're dying and you haven't appointed a healthcare representative, your spouse can make decisions about tube feeding and life support just because you're married, but not really like Alzheimer's care and other just types of care. Although for the most part, as an informal matter, that's pretty much the way it works. And spouses generally are allowed to do that sort of thing. And of course, that's one of the reasons that marriage is recognized as such an important thing, and why people fight for the right to get married. And funny thing though, it's like, honestly, under Oregon law, that's, you can be married and still not really have that much legal authority to direct your spouse's incapacity issues. So you got to do it through legal planning. Okay. So when we're talking about financial incapacity, the most essential and basic tool is called a power of attorney. So there's a lot of misunderstandings about what powers of attorney do in Oregon in particular. I get asked all the time, is there some sort of a problem with my power of attorney because it doesn't say durable? Or what is durable? Or, is there some sort of like special kind of power of attorney that I need? And the other area of major misunderstanding is that if you sign a power of attorney, the person that you've appointed on the form is like your boss, and they get to make all the decisions for you, and you don't make any decisions yourself. You're giving up rights. And the other big misunderstanding about powers of attorney is that they cover everything. They cover, all you have to do is sign any old piece of paper that says power of attorney, and then you've adequately given enough authority to somebody else so that if you do have full-blown Alzheimer's, they can handle every financial transaction there is, no matter what it is, and also make all your medical decisions for you too. So none of what I just said is true. So here's the deal with powers of attorney. So number one, it's not enough to just sign any old form that says power of attorney, even if it says durable power of attorney, even if it says general durable power of attorney. Some piece of crap form that you download off the internet is generally not a good idea. Now, that's not universally true, but it's generally enough true that you shouldn't do it. In fact, this little document, which will cost, a few $100, not a fortune when it comes to legal services. That's the main reason you should go see a lawyer, is to get a good one, okay? I mean, among other reasons, but like if you do nothing else, but just see a lawyer to get a good, and really an elder law specialist, to get a good power of attorney that truly covers the bases if you are incapacitated, that's probably the most important thing you can do in your estate planning. Why? Well, number one, it's going to cover more transactions. So the idea behind a power of attorney for finances is that it's designed to cover all sorts of different transactions. That's what the general means. It's not limited to one transaction. If you go to the DMV and sign a power of attorney, you're getting a limited power of attorney that lets somebody sell that car. That's it. That's all it does. A general power of attorney will let somebody sell any car and file your tax returns and sell your house and get into your retirement accounts. And really important for long-term care, transfer your assets to somebody else, even if that somebody else is the person you appointed on the form as the agent. That's the missing ingredient that is you won't see in probably most powers of attorney. Why should I sign a form where I give the power to somebody to take my money and property and give it to themselves? That's crazy, right? Because that's what happens in long-term care. Who are you going to put on this form? Probably your spouse, if you've got one, probably your kids, your adult kids, if you've got them. If you've got Alzheimer's and you're looking at, I'm not making this stuff up, like $8,500 a month of long-term care costs, and you're not made of money, you're going to probably have to qualify for Medicaid to help pay for your long-term care. Medicaid has some very archaic, not so great rules about, what you have to spend and how do you support your spouse and can you support your kids. They're not great rules, okay? But what there are is, you need to be able to put assets in your spouse's name. So you put your spouse on your power of attorney because of course you do. Who else are you going to want to manage your money and property if you're incapacitated? You're going to want your spouse. If you don't give your spouse express authority to take the house that you own together and put it in your spouse's name, that's a real problem for Medicaid planning, for asset protection planning. It can make a big difference in terms of supporting your spouse, being able to leave that house to your kids when you pass away, free of a claim from the state of Oregon, things like that. And that stuff's just generally not covered on, certainly not on anything you download off the internet, but also, if you go to a lot of lawyers, you won't get that because lawyers are thinking, why would I write a form for my client that gives the person they wrote, they appointed on the form, the right to take my client's assets and give it to themselves. I want to protect my client. I don't want to give some license for somebody to steal from my client. That's true. If you give somebody the right on your power of attorney to take your money and property and put it in their name, you're risking that you are going to get ripped off by that person. But what if you don't do it? Well, now you've just substitute that risk for another risk. Now you're risking that you'll get Alzheimer's and you won't be able to save the farm, so to speak. You won't be able to put the house in your spouse's name. You won't be able to transfer it to kids if that's allowed and appropriate under the rules. So it's just different risks. And honestly, most people have somebody, not everybody, but most people I see have somebody that they feel pretty damn good about putting on a power of attorney with the broadest possible powers, and they're sleeping like a baby at night. They're not worried at all that that person's going to rip them off. Hopefully that's you. And if it is, that's what you want. You want the broadest possible power of attorney that covers everything, stuff you never even thought about, preferably drafted by an elder law attorney, because that's the #1 tool you can have to protect assets in the event that you need expensive long-term care costs. And that's also, unfortunately, it's the missing ingredient, even from a lot of people who've seen lawyers. So I always talk about it a lot in these presentations because I see that as a problem a lot. So just kind of going back to technical stuff here. So it doesn't have to say it's durable. Durable means that the power of attorney continues to be effective if you become incapacitated, which is the whole damn point, right? So every power of attorney in Oregon under the law is durable, even if it doesn't say so, unless it says it's not. And I've only seen one power of attorney in 23 years of doing this that's not. They're all durable, basically. That's not really the issue. It's what it says. It's the fine print. That's what really matters. So your job is to pick out at least 2, preferably 3 people that you can put on this form where you're sleeping like a baby at night because you're not worried that they're going to use this form to rip you off. So you generally name a primary person and then a backup to that person in case that person dies, and then a backup to your backup if you can do that. It's okay to name more than one person at the same time. We do it all the time. But now you got to have 2 people that you can put on there where you're sleeping like a baby at night. You have no concerns at all that they're going to use that broad power to rip you off. And they also have to get along well, and they have to be able to coordinate, because we're not going to write a power of attorney that says they both have to sign. That's not going to work as a practical matter. Not on a power of attorney, probably. I mean, maybe it'll work, but chances are it won't. So that's your job. And really that's your job for all of this stuff, is you got to pick the team who's going to be there to manage your business if you're incapacitated. And you kind of like let the lawyers worry about the details. You know, it's like we're the ones that are drafting the powers of attorney, and you're relying on us to make sure it works right. With healthcare decision making, before we go to that, a little bit more about powers of attorney. So they don't cover healthcare decision making. Okay. Now that's not to say that if your spouse has full-blown Alzheimer's, and you show a financial, durable general power of attorney that says nothing about healthcare on it, you could very easily show that to your spouse's doctor and care team, and they'd say, okay, you're in business, no problem. That's just because people don't understand what powers of attorney do and don't do. They don't cover healthcare decision making. I mean, you might see a power of attorney that is written so it does cover healthcare power of attorney. I mean, they're out there, but for the most part, they don't. That's the Oregon Advance Directive. Okay, that's what that document does. That's the healthcare document, and powers of attorney don't really go there. And the other thing about powers of attorney, before I move on, you don't give up any rights when you sign a power of attorney. You still have all rights, and you can revoke it. It's just sort of a power sharing agreement. I can do all these things, so can you. Some powers of attorney don't become effective. The person you put on the form doesn't have any power to do anything for you until you're deemed incapacitated. That typically means your doctor. I'm belaboring this, so I don't want to go on too much longer. I have some problems with that. Like, really? Is your doctor better equipped to determine when you're incapacitated, better than your spouse and your adult children? Really? Okay, that's maybe what should be going on in your mind if you're thinking about doing a power of attorney where a doctor has to say you're incapacitated. But some people do it. That's okay. So let's talk about healthcare decision making. So that's the Oregon Advance Directive. And that's another form that's really widely misunderstood, because when you look at it. And this one you can, and people do download. There is the standard form, the Oregon Advanced Directive form. You Google it, you download it, that's the form. It doesn't say, this is the person that I'm appointing to make medical decisions for me if I have Alzheimer's, and my healthcare representative has the following authority to make medical decisions for me if my doctor says I'm incapacitated. And then there's like a list of the authorities, the powers that your healthcare representative has. That's what powers of attorney for healthcare look like. And we don't really use those in Oregon. We have an advanced directive that says, I appoint fill in blank as my healthcare representative. I appoint fill in blank as my alternate healthcare representative. Sign here to appoint a healthcare representative. That's it. What are you doing if you sign that? Well, you're appointing the person who makes fundamental decisions about you if you've got Alzheimer's, for starters, like where you're going to live. You're going to live at home? You're going to live in a foster care home? Are you going to live in memory care? Are you going to go back to Tennessee and live with your grandchildren? Who decides that if you've got full-blown Alzheimer's and can't make those decisions yourself? Well, the starting place is, have you signed an advance directive? Okay, who did you name as the healthcare rep? Okay, that's the person who's going to make those decisions, probably. Does the form say anything about that? Not a word. So you kind of have to know, and it's also the person who would authorize medical treatment. So you've got Alzheimer's, or you had a stroke, or you had a heart attack, or you had a car accident, and you can't direct your own care. So this is the person that the doctors consult with and who authorizes care, who provides informed consent for treatment. And it also deals with end-of-life care. Now, people understand that because there's pretty straightforward language. Do you want tube feeding or other life support if you're close to death? Do you want tube feeding or other life support if you are permanently unconscious? You know, so that's fairly straightforward. That is very important. You need to fill that out and say whether you want tube feeding or life support in those situations. I get asked all the time, you know, if I have Alzheimer's disease and I don't really have any quality of life, I don't want to be kept alive. So where's the form that I can sign that says that that I can, you know, be allowed to die naturally or just die if I have full-blown dementia and no quality of life? And the answer is there ain't no form for that. There's the advanced directive says that if you've got advanced progressive illness, advanced Alzheimer's, to the point where you can't swallow food and water anymore, to the point where you can't communicate, you can't, you know, recognize family, but it's like the point where it is a fatal disease. And under those circumstances, your healthcare representative can, if you've selected the box that says no tube feeding, discontinue tube feeding and let you die naturally. But that is different than just full-blown Alzheimer's, no quality of life, but it's not a fatal, it's not in its fatal stage. There is no jurisdiction in the world that authorizes somebody to discontinue life support on behalf of another person under those circumstances without, you know, that being a criminal offense. And what about assisted suicide? You have to be competent to do assisted suicide. In fact, you have to get 2 doctors to certify that you're competent. You know, that's for people that have a terminal illness, like 6 months to live, and they're competent to make the decision and they self-administer the drugs. And, you know, there's not a lot of jurisdictions in the world where you can do that, but they're growing. Oregon was a real leader in that, Washington, now California. But that's not about, you know, Alzheimer's for the most part. So that's kind of like the basics of giving somebody the authority to make decisions for you about incapacity. You need health directive, you need power of attorney, and those are real basic. They're not expensive. In my office, you get a much better advanced directive than the standard form because we do put a whole bunch of extra language in there. But honestly, the standard form is adequate as long as you understand what you're signing. But don't do your own power of attorney. Okay, so now we're going to shift gears. We're going to talk about what happens when people pass away. So your job is to figure out the plan. You know, this is who gets what when I die. And who's going to handle the business when I die. So who's going to be the person that files my taxes, sells the property, pays my debts, deals with the lawyer, deals with the accountant, distributes to my beneficiaries, okay? When you're thinking about, you know, who gets what when I die, most people, it's pretty simple. You know, I leave everything to my spouse. If my spouse dies before me, I leave everything to my kids in equal shares. If any of the kids die before me, it goes to their kids in equal shares. Great, perfect, wonderful. No need to get off that track. But of course, that's not what everybody wants. Not everybody's married, not everybody has kids. Even people who are married and have kids, why is it different than that? The major reasons that it would be different from that would be, first and foremost, you've got beneficiaries who, for whom the receipt of an inheritance may be problematic in some way or another. Why? Well, probably the number one reason would be a type of disability. So not just, you know, being disabled in some way, but some way where either there's a disability that causes some real concerns about the ability to manage assets, like people that have cognitive impairments, developmental disabilities, things like that. They really probably wouldn't be able to manage a large sum of money or even a modest sum of money. They would need somebody appointed for them as like a money manager. And that is one reason that when you're leaving an inheritance to somebody else, you might want it to go inside a trust, or a trust created by your will, which is called a testamentary trust. In other words, it's just a way of leaving an inheritance to somebody with some terms and conditions attached. And built into that is somebody called a trustee, who's going to manage the inheritance on behalf of this incapacitated person, or this person maybe who isn't incapacitated, just maybe doesn't have the best judgment. Or maybe they're just young. You got an 18-year-old beneficiary. Maybe it's not a question about disability, it's a question about maturity. Do I really want my 18-year-old beneficiary to get a bunch of money, no strings attached, no responsible adult? Probably not. So I create a trust and I appoint a trustee to manage that kid's inheritance until she reaches the age of 25 or 30. You can put terms and conditions in there. This is only for paying for higher ed. It's an educational trust. All sorts of things. I mean, really, it's only limited by your imagination. People do the darndest things in wills, trust me. But, you know, for the most part, it's pretty straightforward. Most people don't do that, but you do need to think about whether you have beneficiaries that maybe have a disability, maturity issues. Sometimes you're just talking about kids. What if you got a 6-year-old beneficiary? Well, a 6-year-old can own anything, but they can't manage their own assets. They have to have somebody manage assets for them. And when you do a proper will that sets up a trust for these kids, you're selecting the trustee, the money manager. You're determining the age at which it ends, probably not 18, probably an older age. You're determining the terms and conditions. You're going to say, what happens if that kid gets the money and dies? Where does the money go? You get to make those decisions. If you don't do that, and you just name a 6-year-old kid on your will, or more likely, maybe you do have a will that sets this up, but you have an IRA, you have a retirement account, and you just name the 6-year-old kid as a beneficiary of the retirement account because you think your will that's got it all set up is going to cover the retirement account, but it doesn't. Totally different than your will. So on your retirement account, there's just the kid named as the beneficiary. When kids receive inheritances that are not set up in trust, it's usually an expensive legal problem. Usually somebody has to hire a lawyer. We have to go to court. We got to get the court to appoint a money manager. Very expensive. And it ends at 18, not at 25 or 30 when you would have, you know, if you were thinking about it, that's probably what you would have done. So there's all sorts of issues about that. I'm going to focus on a real important subsection of that, which is a spouse with Alzheimer's, a spouse with Parkinson's, a spouse with MS, a spouse that has mobility impairments, that needs assistance going to the bathroom, getting dressed, a spouse who might need expensive long-term care, okay? So that's somebody where, you know, Medicaid might have to enter into the picture to help pay for long-term care. And if you have the normal will that says, when I die, everything goes to my spouse, period, that is a problem. Well, let me put it this way, it's not a problem, but it's not an asset protection way of looking at the world in your will, okay? That means that if the unimpaired spouse is the first spouse to die, all of the couple's assets are now owned by this impaired spouse. And that's a very difficult way to protect assets from being spent on long-term care. Most of the Medicaid planning, asset protection planning that we do is for married people, where it's about getting as much as possible over to your spouse so that the impaired person can qualify for Medicaid. Medicaid doesn't allow you to have really any assets. So if you're in that situation and you're thinking about your will, well, you really need to talk to an elder law specialist, because you can set up trusts for the benefit of your spouse where the assets you leave your spouse are protected. They don't have to be completely exhausted paying for long-term care before your spouse can get Medicaid to help pay for long-term care. These are called special needs trusts. Now, special needs trust is something that we could talk about for an hour or 2 hours just on that, because there's a lot of different kinds of special needs trusts. I'm talking about a very specific kind of spousal planning here, where you've got a spouse with an impairment. You want to leave assets to the spouse, but you want to leave it in such a way that those assets don't have to be completely exhausted before your spouse can get some help paying for long-term care. And once your spouse does get help paying for long-term care, the assets in the trust supplement his or her care costs. So the goal would be to put the brakes on the catastrophic amount of spending you're going to do paying for long-term care. This is not a magic bullet. It's not like we could just say your long-term care is free. Great. But it can make the money you have go a lot further. You're going to spend a whole lot of money on long-term care, but if some of it is in a special needs trust after the one spouse dies, that portion wouldn't have to be spent. You know, you might have to spend a whole lot more of, a whole lot of other assets, but there'd be a portion at least set aside that can be used to supplement your spouse's care to get the highest quality of care, and then also go to other family members when you both die. So having an impaired spouse is a major reason to be thinking about a more than garden variety estate plan for you, okay? Last thing I'm going to talk about with just estate planning, what happens when you die kind of thing, is wills versus trusts. So I've already talked about trusts, but when I was talking about trusts up until now, I have not been talking about your trust. I've been talking about a trust that you set up for somebody else when you die. It's inside your will. It's called a testamentary trust. It doesn't exist until you die. And then it's funded with assets that you own at death under the terms set out in your will. It's a way of leaving an inheritance to somebody else. But there's also something called a revocable living trust, which is your trust, okay? It's like it's like an alternative to a will as a way of doing your estate planning. And this is what most people are probably hearing when they hear people talk about trusts. These are the most garden variety trusts. It's instead of doing a will, you do a revocable living trust. Why? It makes it a lot easier, cheaper, and quicker to wind down your estate when you die. That's why, okay? So a revocable living trust is a lot like a will. It says, when I die, I leave everything to my spouse. If my spouse dies before me, it goes to my kids. Or it says, when I die, I leave money to a special needs trust to my spouse. Or, I've got a 6-year-old kid, so when I die, it creates a trust for my 6-year-old kid. Everything you can do with a will, all the things we just talked about, you can do the same with your revocable living trust. It's a will substitute. It's just like a will. The difference is that when you die, you have empowered your representative, which is called a successor trustee, to just carry out your instructions. That document is giving the power to the trustee to go down to the bank, take the money, sell your house, go to Fidelity, get their name on the investments, pay your bills, pay your taxes, sell your house, distribute the money according to the terms. Your successor trustee has all the tools that they need to just go ahead and do that when you die. With a will, first stop is the lawyer's office, because your representative, called the personal representative in that case, does not have the power to just carry out your instructions when you die. Wills cover assets just in your name that do not name a beneficiary at the time that you die, okay? So there's a house, it's just in your name. You did not do a deed that names a beneficiary. If you die, that's what your will does. It covers that. And oh, by the way, if you don't have a will, fine. The state of Oregon has a will written for you. It'll go to your next of kin. Okay, that's what wills are. That's what no will is. It's for the assets just in your name that don't have beneficiaries. So what's not on that list? Well, let's say you've got an IRA, an individual retirement account, and you name beneficiaries. Okay, that money goes to the beneficiaries. Doesn't matter what your will says. What if you have a bank account that you own with your next door neighbor? Okay, you die, that's your next door neighbors. Doesn't matter what your will says. Okay, so, and trusts. If you do a trust, you've got to go through the process of titling your assets in the name of that trust. In other words, in your name as trustee of the U Trust, or you and your spouse's names in the name of the Miller Family Trust or the Jones Family Trust, because it's very common for couples to do trusts together. So the difference is that if you've gone through the trouble of creating a trust, and you've gone through the trouble of deeding your house to the trust, and you went down to Wells Fargo and you put your bank account in the trust, and you took your Fidelity account, you put it in the trust. Now when you die, there's a trustee, a successor trustee. They can go down to US Bank and say, I'm here on this document. Here's the death certificate. Mom's dead. I want the money. And they get the money because it's in trust. But if you show up at Wells Fargo and the bank account is in mom's name, just her name, no name beneficiary, you show up with the will, it says right here, I'm in charge. Give me the money. You don't get the money. They say, go get letters testamentary. What does that mean? That means you're calling the lawyer. We're opening up a court procedure. We have to go to court to get a judge to appoint you formally as the personal representative of mom's estate. And then you are in court. And you have all these obligations to the court. There's all these hoops you got to jump through. It's going to take 6 to 8 months with COVID. Make that 8 to 10 months. It's going to cost $5,000 to $7,000, sometimes $7,000 to $10,000, sometimes more. Okay, it's just you're in court. It's a judge supervised process. It's very technical. It's a lawyer-driven process. It's expensive. Nobody gets an inheritance for 8 months, on a good day. With trusts, it can move along much quicker because the trustee can get their hands on the money right away, can distribute right away. So it just makes it cheaper, quicker, easier to wind it down when you die. That's the main reason you should consider a revocable living trust versus a will. They are more expensive. That's the main reason you should not consider a revocable trust. When you're weighing will versus trust, you're taking the long road. Okay, you're thinking in the long road, I'll save money. Yeah, it's going to cost me more, but when you factor in the savings when I'm deceased, in the long run, you save more money. Not everybody can do that. There's a lot of people who can't afford to do that. There's a lot of people who don't want to do that. That's okay. You can do a will. It's fine. It's better to do a trust, particularly when you have people depending on you for support. If you have somebody depending on you for support, do a trust. because it'll take a really long time. There'll be, you know, you die, the support's going to stop until, you know, it's just going to take a really long time to get through the court system to the point where the support's going to continue. Okay, so that's it for your dad. We're going to now talk about, the rest of the talk is going to be about Medicaid and long-term care planning, okay? So I've already talked some about Medicaid, but let me kind of take a step back and talk about it and, you know, what the hell are we talking about here? So if you need assistance with activities of daily living, getting dressed, going to the bathroom, taking showers, dementia care, going to the, you know, those kinds of things, that's considered long-term care, and it's basically not covered by medical insurance. It's not covered by the policy you get from your employer. It's not really covered by Medicare. It's not covered by your Medicare supplemental insurance policy. Now, again, this is a little bit technical. I mean, it is true that Medicare will pay for a nursing home under certain circumstances, but that means you've been in the hospital for 3 days, you've been discharged from the hospital to a skilled nursing facility, and you can maybe get up to 100 days of that nursing home paid for by Medicare, although you won't get a full 100 days probably. What I'm talking about is like, well, then what? You know, so you've been in the nursing home, and now they're like, okay, you're not getting skilled physical therapy anymore, or occupational therapy, or speech therapy. And so now you still can't live independently. You still need help going to the bathroom by yourself. You still got dementia. But, you know, if you want to stay here at our wonderful nursing home, it's $13,000 a month. Or, you know, we're going to discharge you to assisted living or an adult foster home, or maybe home if you're lucky, if you've got the caregiving set up at home. But, you know, for most people, this is a really expensive proposition, and there really isn't medical coverage for it. There is such a thing as long-term care insurance. So there are some people that do have policies that cover this, but you can't buy it if you need it. So if you've got Alzheimer's, if you've got MS, if you've got Parkinson's, or for that matter, you just have high blood pressure or, you know, joint pain, might be kind of hard. I mean, it's impossible to get a long-term care insurance policy if you've got Parkinson's disease, no way. But even if you've got just, you know, normal signs of aging, you might not be able to get insurance. Plus, they're really expensive. So it's not a tool for somebody who finds out, oh my God, I need long-term care. Oh, I better go buy some long-term care insurance. No, that's way too late. This is people who buy long-term care insurance are buying it as sort of like part of their general retirement planning. Think of it along the lines of like paying for your, you know, funding your IRA. You know, should I buy a Roth? Should I get long-term care insurance? And that's kind of where that discussion comes in. If you have it, there's a lot to like about it. There's things not to like about it, but there's a lot to like about it. It pays cash if you need help with usually 2 out of 6 activities of daily living or dementia. And the 6 would be like going to the bathroom, taking showers, getting in and out of bed, mobility. You know, there's like a list of 6 things. They're pretty standard. They're regulated in terms of the eligibility requirements. So there won't really be any difference between policy A and policy B in terms of when they pay. And they all cover Alzheimer's disease and different types of dementia, and they pay cash. So it's not like an HMO where you have to go to this facility and that one's out of network, so you're screwed. They just pay cash if you need care. And the more, you know, here's a, you know, word to the wise, the more you pay to get the thing, the more it pays you when you need it. It's as simple as that. And it's expensive, and that's all I'm going to say about it. If you don't have long-term care insurance, like most people, how do you pay for long-term care? Well, you pay for it with your money. You pay for it with your assets, you know, IRAs, savings accounts, stocks, bonds, the things you've got. Most people just pay for long-term care, and it's really expensive. Let's just say, rule of thumb, expect to pay $6,500 a month. There are some people who pay less than that. There's a hell of a lot more that pay more than that. Way more people probably pay more than that. I don't even know if 6,500 is even the median anymore. it's kind of a rule of thumb, but I think the thumb is getting longer as we get older. So real expensive. So, you know, what do? Well, there's Medicaid. Okay, so Medicaid, the deal with Medicaid is that if you qualify, it will pick up most of the cost of an assisted living facility or a foster home or a memory care facility or a nursing home. In Oregon, not true in other states. In other states, it's nursing homes, okay? But Oregon has done a really good job of broadening the field so that there's a lot of different types of care facilities that participate in Medicaid. Do they all? No. They don't have to. You know, like virtually all the nursing homes do, but that's not true for assisted living, foster homes, memory care units. Some do, a lot don't. It's just up to them. But if you're in a place that takes Medicaid and you meet the financial eligibility criteria for Medicaid, and you also have enough of an impairment to qualify medically under the Medicaid rules, the deal is the most you can pay to live there and get the food and the place to live and the meds and the assistance, the most you can pay for the whole package is your monthly income. That's the most. And I'm saying your monthly income. Your spouse's income is your spouse's. I'm talking your monthly income. So your Social Security, your pension, your fixed monthly income, that's the most you can possibly pay for full care, full services, place to live, food to eat at an assisted living, foster home, nursing home, what have you. That's the deal with Medicaid. Quality of care in Oregon is really good, which is not to say there's not problems, which is not to say there aren't a bunch of shit places, bunch of lousy places that take Medicaid. But you know what? There's a bunch of lousy places that don't take Medicaid. There's a bunch of people getting lousy care in places that don't take Medicaid. In Oregon, for the most part, the quality of care is not so much about is this the Medicaid place? And guess what, folks? In most states, that's exactly the way it is. That's exactly the way it is. In most states, the Medicaid places is the place that you don't want to go, you don't want your spouse to go, you don't want your mom to go. Oregon has done a really good job of integrating the Medicaid population in with the private pay population. That's the model, that's the goal. There's problems with it, but that's the goal. And compared to other states, we're way ahead of the curve, way ahead of the curve. What about Washington? Good question. It's a little more nursing home centric in Washington. That's not entirely true. It's a little harder to get Medicaid to pay for community-based care, not nursing home-based care. It's harder to find community-based care that takes Medicaid in Washington, but that's, I'm not going to go into a bunch of detail about that, but Oregon is pretty good when it comes to quality of care. So that's the deal with Medicaid is instead of paying $6,500, $7,500, $8,500 a month, you might be paying $1,000 because your income is like, a little over $1,000. And oh, by the way, if you're married and your spouse doesn't have a lot of income, you might pay very little. Maybe you're only paying like $700 to live in an assisted living because there are rules that allow your income to go to your spouse to support your spouse if your spouse has low income. Okay, and if your spouse is working or has, a pretty big pension, you're not going to be able to divert some of your income to your spouse to support your spouse. But a spouse that just has Social Security, a spouse that, just doesn't have a lot of income, chances are pretty good if you qualify for Medicaid, your income will be allowed to go to your spouse and you might not pay very much at all for full care at a care facility. Plus, if you qualify for Medicaid, you do also get an extra layer of health insurance on top of what you already have. So you keep your Medicare, you keep your Medicare supplement, and then you get Medicaid on top of those things, and that picks up your out-of-pocket costs. So no more prescription charges, no more co-pays, deductibles, co-insurance, It's all covered. So it's like complete medical care, and you might be living in a assisted living facility for $1,000 a month. Okay. That's why people know about Medicaid, because that's for most people that are on Medicaid, that's the only way. They can't pay $6,500 a month, right? So how do you qualify? So we have 8 minutes left. I'm not going to go into all the details. This is a 2-hour talk, but here's the basics. The person who needs Medicaid, number one, has to meet medical eligibility criteria. Guess what? It's not enough that you just can't live independently. That's not the rule. It's you have to have a problem with certain activities of daily living. Going to the bathroom, transfers in and out of bed, transfers in and out of chairs, mobility, even with a walker or cane. You have falls or need standby assist. Really, those are the three. Going to the bathroom, getting in and out of bed, in and out of chairs. And what did I else say? Bathroom, mobility. Mobility, walking, ambulating, even with walker or cane. Or dementia, but not mild dementia, pretty, a little bit above mild dementia. So that more like mild to moderate is probably where you want to be. Very technical, you can't go into all the details, but basically that's it. So, if you need help bathing and maybe some reminders to take your meds and dressing, but you can do those other things, you may not be able to live independently, but you're not eligible for Medicaid. That's number one. Number two, financial eligibility criteria. So the person who needs Medicaid can basically have $2,000 in countable assets. $2,000, okay? Low as low gets. So there are different rules for married people. Let's talk about unmarried people first. So it's pretty straightforward. Basically, everything you have would be considered a countable resource for most people. Savings account, checking account, IRA, stocks, bonds, real estate. What about your house? If you're not married, you have to live in it. Or you could have a disabled child or some disabled person, somebody who relies on you support, a family member who relies on you for support, who's got a disability, who lives in that house. So assuming you don't have a disabled child or something in the house, you have to live in it. So that means you're trying to get Medicaid not to pay for an assisted living facility or a nursing home, but to pay for in-home care. Now, Medicaid does pay for in-home care, but not 24-hour a day, 7-day a week in-home care. It pays, you'd be lucky to get 20 to 30 hours a week of in-home care. Now that can work for many people. And there are many people who do own homes and get Medicaid. But for a lot of people, that's just not enough care, because remember what we just talked about, you have to be pretty impaired to qualify for Medicaid. And of the people who are getting in-home care paid for by Medicaid, I'd say more of them are married because they've got a caregiving spouse who's really doing the bulk of the care. But there are loads of people who are living at home and own homes and get Medicaid. They have other family members, adult children, going somebody in the house who's helping take care of them. And then you can own a home. But when you leave the home because you can't live there anymore, now they're going to kick you off of Medicaid eventually, because you're going to have to sell the home. And then when you sell the home, you've got money. You have to spend down the money to $2,000. But you are allowed to have personal effects and a car of any value. And if you live in the home, you can own a home. But there's an asset cap. It can't be more equity in the home than about $600,000. With married people, and this is how we're going to conclude, there's much more generous rules, not for you, the person that needs Medicaid, but for your spouse. So your spouse, first of all, if your spouse lives in the home, then you can have a home, any value. Second of all, your spouse is not limited to $2,000 of assets, but there's some complicated rules about how many assets your spouse is allowed to have in addition to the home. So here's how they do it. The day that the impaired person, the impaired spouse, let's just say it's husband. Let's say husband, the day husband goes into or leaves the home to go to the hospital, and then goes to a nursing home, and then goes to assisted living, and never returns home. The day husband leaves the home is what we call the start of continuous period of care. What you have to do is look at the assets that the couple owns on the day that starts the continuous period of care. So the day he leaves the home and never returns home. What does the husband own? What does the wife own? And in this instance, just to make it easier for me, it's husband and wife. It could easily be husband and husband, wives, whatever. But just bear with me here. So husband and wife, on that day, we need to know, what do both of them, either of them, what do they both own? You cannot just put everything in wife's name and say, husband's only got $2,000. He's eligible for Medicaid. No, because when you're assessing the assets, you look at everything either one of them owns, including everything they own jointly with the kids. Everything that's got husband's name or wife's name on it, we're looking at it. And we're counting it all up. And as long as the wife lives in the home, we don't care about the value of the home. One car we don't care about. TVs, furniture, jewelry, toaster ovens, we don't care about that. Everything else we care about. IRA, 401k, savings for either spouse. Stocks, bonds, real estate, other, the beach house, that second car, the third car, the boat, the RV. We're looking at all of that. We add it all up. Long story short, if it's bigger than about $260,000, wife is allowed to have a maximum of $130,000 house and a car. If it's under $260,000, wife gets half of what they had the day that husband left the home and never came back. So in other words, wife and husband have $100,000, house and a car, the day husband slips on a banana peel, breaks his hip, nursing home, skilled facility, assisted living, didn't make it back home. That was, let's say, January 1, 2021. Husband's eligible for Medicaid the day that wife can show that they have $50,000, a house and a car, basically. Okay? So you have to spend down half of the assets. And if on that same day, January 1, husband and wife had $300,000, a house and a car, husband is eligible for Medicaid the day you can show that the $300,000 has been spent down to $130,000. That's the max. And oh, by the way, if they didn't have a whole lot the day that husband left the home, they had less than $26,000 between them, they don't have to spend anything. He's eligible now. So the asset rules for spouses is there's a minimum $26,000 house and a car. There's a maximum $130,000 house and a car, but most people spend down half. It just depends on how much you've got the day that the spouse begins the continuous period of care. Elder law attorneys specialize in advising you about how to do a spend down. That's a big part of what we do. So you're one of those people that has $300,000, a house and a car. You now know that your husband won't get Medicaid until you've spent down the $300,000 to $130,000. What do you do? Well, that's what we talk about. And sometimes you pay off debt, pay off your mortgage, but there are some things that we can do so that that money that you have to spend down doesn't just go straight to that care facility. We're trying to figure out a way to get that money to the spouse, to support the spouse. And there are some techniques that we can do so that you don't just spend down paying for care. You spend down, you're going to pay for care. You're going to spend a bunch of money on care. There's no silver bullet. But we're trying to get as much of that spend down money over to the spouse to provide additional support to the spouse. That's why people go see elder law attorneys. Also, if it's possible, this is a big, long question. It's being litigated, but if it's possible, we would like to support the spouse in such a way that when the spouse dies, the state of Oregon does not have a claim against her estate to recover the cost of Medicaid. Big question. Like I said, it's in litigation. There's case on point that we're handling right now in the Oregon Court of Appeals. Big issue. But that's why you go see an elder law attorney if your spouse has got dementia. I mean, for a lot of reasons, but so that is your 50-minute elder law estate planning overview. Okay, so I imagine there's some questions, and I also want to say that I'm not the expert on Washington. I mean, we have experts on Washington in my firm. I'm just not one of them. I can give some general info, but I'm not the Medicaid expert in Washington, but we have a lawyer named Shannon Conley, who is the Medicaid expert for Washington. She's fantastic. She can help people who are in Washington. So hit me with your questions.
Thank you, Garvin. This was very informative. You raised a number of issues, and I know we have a number of questions today. I'll start out with the first one. For people that maybe didn't do the planning ahead that they should have in order to have power of attorney issues taken care of, talk a little bit about, I know it's going to vary in every situation, but what's the process of a loved one and the aging relative figuring out power of attorney issues?
Great question. So the problem is that there's like a line out there that's too late, basically. Okay. It's a little hard to say what that too late line is, where you're no longer capable of signing a power of attorney. You're no longer capable of signing an advance directive. That line is called incapacity. We could talk a lot about, who figures that out. Let's just say that it's usually the lawyer who has to figure that out. And let's just say that we've got somebody who has crossed that line, and there isn't a lawyer out there who's willing to say, yeah, this client's capacitated and I can vouch for that, and I'm going to prepare a power of attorney and a health directive for my client, and so we've got somebody who's incapacitated, and they've got money, they've got healthcare decisions, they've got issues, and there is nobody empowered to handle those things for them. What happens? Well, that's what courts are for. That's what judges are for. So basically, we have legal proceedings called guardianship and conservatorship, where you go to court, a court appoints somebody to manage assets, a court appoints somebody to make medical decisions. Conservatorship deals with assets, guardianship deals with where you're going to live, type of healthcare you're going to get, dementia care issues, not money, but issues of the person. So that's what happens, is people that don't do planning, who have issues, needs a decision maker, the courts have to appoint somebody. And that's not beneficial because, number one, it's expensive, way more expensive than estate planning. Number two, you're not deciding who your decision maker is. You didn't decide. So now, it's like you don't have no control over who's going to go to court and ask to be your representative. Okay. So it's not a good alternative to signing a power of attorney or something like that. But it is like conservatorship is appropriate in cases of abuse. Somebody is ripping you off. Okay. We need the courts to step in and solve that problem, but it shouldn't be a substitute for just estate planning.
But Willie had a question. She said, does the recipient of a revocable trust have tax implications?
Recipient, you mean somebody died and you got an inheritance?
I believe that's what she means there, yeah.
So that wouldn't matter if you use a trust, a will, or for that matter, no will or no trust.
No, I mean, I do the revocable trust, I write it today. And would then my daughter, and give it to, say, my daughter, would she then have to pay taxes on that?
So I'll give you a long-winded lawyer answer. So today, I see you're alive, you're kicking. So if you're going to do a revocable living trust, you're going to be the owner. You're going to take your money and property and put it into the you living trust. And when you do that, no difference whatsoever tax-wise. You're the owner. You don't tell the IRS that you do it. Doesn't reflect how you file your taxes. Not very many differences between you owning your assets as you and you owning your assets as you, comma, trustee, comma, of the you trust. Same thing. Now you're dead. Your daughter gets everything in the trust. The general rule for inheritances is they're not income. You do not report in an inheritance as income. So you get a beach house, you get 50,000 bucks, you inherit a bunch of stock. That's not income. You don't report that to the IRS. It's completely tax neutral. Okay, asterisk. That's not exactly the way it goes. So if you die with more than $1 million, you pay some tax. So if you die with $2 million, you first have to pay the state of Oregon $100,000 estate tax, and then your daughter gets 1.9 million. Free.
What if, can I have both my son and my daughter?
Yeah, no problem.
To make that go down to under $1 million?
Nope, you only get 1 million to the entire universe of people.
Oh.
If you're married, you can leave any amount to your spouse. You can also leave any amount to your favorite collection of nonprofits. But for people that you're not married to, you're capped at $1 million. So there's an estate tax, but the receipt of the inheritance is not subject to income tax. Of course, it's way more complicated than that, but that's your basic general rule.
Okay, thank you.
We had a question from Mike Bruchet. He asked, when a person goes into long-term care, is there an upper limit of the home value that is considered?
If you're not married, you're an unmarried individual. First of all, you have to live in the home, or you can have a disabled child or a disabled dependent relative living in the home. But if you don't have that, then you have to live in the home. And there's an equity cap of around $600,000. So if you have a home with home equity of $900,000 and you're trying to get Medicaid to pay for in-home care, not going to work unless you're married or have actually, I don't even think the disabled child works for the asset, for the equity cap. You have to be married. If you're married and your spouse lives in the home, there's no equity cap on the home equity. You can have a home worth any value, any amount of home equity.
Okay, we had one question that was a little bit unusual. How does elder care work for those expats that move outside of the country?
Well, there's no such thing as Medicaid for somebody that's not living in the United States. That doesn't exist. That's the bad news. The good news is that most countries have better long-term care services than the United States, not in the sense of like nursing homes, but in the sense of like domestic assistance. So honestly, if you're living in Argentina, hiring domestic help is probably like a third of the cost or less than paying for like a nursing home in the United States. So there's a lot of countries where that's what long-term care is. It's mostly family, but if it's not family, it's domestic help. It's people who do, home services. And that is, a widely available and not catastrophically expensive thing. But there's no such thing as Medicaid coverage outside of the United States.
Right.
I'm looking at a bunch of questions here in the chat. Okay. So Washington, I'm skipping that. Tax, okay, we talked about that. Okay, what about the bank's rule regarding POD, pay on death? Okay, so, there's lots of different ways that you can set up your assets to go to somebody else when you die. Lots and lots of companies are getting in on that game. So come to my bank. You can open up a bank account and you just fill out a little form and says who gets the money when you die. That's called pay on death, POD. You can also see it called transfer on death, TOD. Great, fantastic. What's the downside? Well, sometimes there's no downside, but you might, number one, have a complicated estate plan. You want 50% to go here and 25% to go there. And if this guy dies, then that guy gets it. But if that guy dies, that guy gets it. You can't do all that stuff through a little form that you fill out at the bank. Number two, you might have like a 6-year-old kid and you need a trust for your 6-year-old kid. You can't do that on a little form you fill out at the bank and let it's like you still have to figure out things like that. So also, if you have a will or a trust and you change your mind, you can sort of sweep all of your assets and say, I hereby change the plan, and now somebody else gets the money, and you just sign your trust. But if you've got this asset with a POD and that asset with a POD and then another asset with a POD, you got to go to all 3 banks and fill out forms at all three places if you want to change the inheritance plan. So it can be great. It can be fantastic, but there's sometimes you're better off having like a master blueprint plan called a will or a trust that sets out the rules. The other reason that can be really problematic is if you do have over $1 million and there's a state tax. How do you get that person who, so you die with a POD bank account, you're dead, the person just walks down to the bank with the death certificate, they give them the money. Great, perfect, wonderful. What's the problem? Well, that person actually owes $10,000 of estate tax. They're not handling your estate, somebody else is. So that person's got to track down that person who just got the money and say, I need 10,000 bucks to pay your share of the taxes, buddy. That can be problematic because it's not all going through the hands of a person in charge of the estate. So that's my answer to that. Let's move on. How did the expats? Is it okay to not have a trust when you have made your children beneficiaries at every bank in retirement? Well, that's the question that I just answered. And I think I just answered that. Sometimes it's great, not so great with taxable estates. I wouldn't recommend it if you got more than $1 million for lots of different reasons. There's nobody in charge. And the thing is, you know, you maybe fine for your bank accounts and retirement accounts, but what about your house? Do you really want your 3 kids to be the owner of your house the day you die? Maybe. Could be great. Could be a cheap, easy way to avoid probate. Don't need a trust. But now, in order to sell your house, all 3 kids have to agree on every term. All 3 kids have to sign every scrap of paper. One kid who thinks, you know, doesn't really go with the program can basically have veto power that would cost a fortune in legal fees to unwind. So it's not always going to be appropriate.
Thank you so much, sir. I think you answered my question, except the house. If there isn't there a way to have a real estate person or a lawyer have a pre-written agreement from the owner that the house is to be sold at my death? And
that's generally called a will or a trust.
Okay, that would go into the will. I'm just trying to think if it's necessary to have a trust if the only asset that's not accounted for is the house.
Well, it depends. I mean, you could name a beneficiary. It depends on what your plan is. Like if your plan is when I die, I just want Julie to get my house. You could do a transfer on death deed and say, why, is it really Julie who gets everything when you die?
How did you know her name?
I made that up. So I don't know. I'm clairvoyant. I'm the all-seeing lawyer.
Also a Reedy.
Oh, well, okay. So go Julia. That might be fine. Okay. So you could do a transfer on death deed that says Julia gets the house the day I die because I named her as the beneficiary. But honestly, I'd need to know more about your plan. I'd need to know, well, what about where does everything else go? Is it a taxable estate? So if it's really simple, that's when it works the best to do those informal alternatives to a trust. Okay, simple.
Yeah, thank you very much.
You bet.
There's been some talk in Oregon as well as other states about raising that $2,000 limits to make it a little more reasonable for people to survive while receiving long-term care. If you were to give this presentation 3 years from now, do you think we'll have some progress on that issue?
Wow, great question. So Oregon does not have the authority unilaterally to just say, hey, guess what? In this state, well, they have some authority, but they're limited in what they can do to change these rules. That's a very complicated question, and some states have modified the rules. It's mostly the rules for married couples that will vary state to state. So for the most part, the states don't really have the authority to make decisions themselves. So you're talking about an act of Congress. Last time I checked, acts of Congress were hard to come by, okay? Our system is not set up for like effective governance. We're really good at thwarting things. We have a great system for thwarting things. we don't have such a great system for accomplishing things at the federal level. And so that's what it's going to take. And yeah, there has been some talk. I mean, I think that's not really the thing, what the questioner asked that I see as the big possible. I think the one thing that I've seen that represents maybe a significant change in sort of the Biden plan is money. They're talking about money. They're talking about giving money to the states to fund long-term care services. Now that's news, okay? I mean, because that's the problem, is the lack of funding. And, but no, I haven't heard anything about increasing the asset level. So, but the deal with Medicaid is, it always changes. It changes all the time. And not only, I mean, so it can change at the administrative level. So, and this is how it really happens. Most big time, huge changes in Oregon Medicaid law are made by bureaucrats, not by elected officials. They're made by agency employees at the Oregon Department of Human Service with virtually no public input or accountability. And that's how, and that changes all the time because they can just say, oh, we're changing the rules. And then somebody like me might jump up and down and throw a fit, and they're like, noted. That's how it changes. So, so things change all the time for the worse. They don't really change for the better. And, but that's what I like about the Biden plan, is that it's one of the for the better things that I've heard. But, you know, there's this little roadblock called Congress. So I don't know what's going to happen.
Here's a good question from the humanist with the ironic name Al Christians. And he would like to know, how does elder care treat Bitcoin?
It's an asset that has to be spent down to $2,000. No, I'm saying that because I don't actually know the rule per se for Bitcoin, but there's a general rule that says that unless an asset is expressly excluded, it's countable. And I'm aware of no exclusion for Bitcoin. So even if there's no rule on point that says that Bitcoin is counted, it is counted. Well, if unmarried with no trusted next of kin, how might someone choose a trustee and or elder law attorney with confidence, avoiding elder abuse? That's a toughie. That's a really tough question. And sometimes people have to use professional fiduciaries. So there is like an industry of professional fiduciaries. There's trust companies. There are what we call private fiduciaries, which are basically like small businesses that where you can appoint somebody to be a healthcare representative, or to have financial power of attorney, or to be a trustee on a trust. And that's probably what you have to do. That's tricky, a lot to talk about there, but that's what most people end up doing. What is the name of the business I'm a member of? Nay and Friedenberg. I'm going to type it.
And we will give Willie the honor of the last question today.
You get the last word.
Are you located in Washington County?
Nope.
Do you have anybody that you can recommend for
the deal with lawyers right now is most of us are working from home. So most offices are closed, including mine. So we haven't had any actual human being clients in our office now for over a year. We are doing Zooms and telephone calls. We have a crew of people back at the office who can help get documents signed, and we're doing parking lot signings. So if we're doing a will for you, and we're gonna do it on Zoom, and we're gonna talk, and then we're gonna email or mail you documents, and then we're gonna do a Zoom and talk about them, and then to sign them, you're gonna drive to my office. Somebody's gonna meet you in the parking lot under the building, put the documents through the window, and you're gonna sign. I don't know what other people are doing. Okay.
Where are you located?
John's Landing in Portland.
Okay.
So there's elder law attorneys all over the place. There are, unfortunately, a lot of people that aren't really specialists who hold themselves out as elder law attorneys. There's not that many specialists, but there's plenty, and there are some in Washington County. And off the top of my head, I actually am not sure who I'd refer you to in Washington County. It depends. I don't know, I'd have to look it up. Most of the really specialist elder law people are in Portland.
Okay.
About assets that have beneficiaries versus those that don't. My husband and I are pretty lopsided. Our house is no big great shakes. It certainly wouldn't be above $1 million, but we would probably be liable to estate taxes if you looked at all our retirement accounts, all of which have our 3 kids as beneficiaries. Number one, do the accounts with beneficiaries, are they included in terms of estate tax? Number two,
Yes.
Rats. Number two, can you do a trust? Should you do a trust just for the house and not the things with beneficiaries?
So that was the part that I sort of skipped in this presentation, was estate tax planning. So that's another 2 hours, but here's, in a nutshell, the answer is yes. A trust can help because there are trusts that are designed for couples with more than $1 million in assets. The upshot of which is they can help you get more than $1 million to your kids free of the estate tax. Okay, so many people who might not even need a trust otherwise do trust simply because of that. Because if you want this, a trust is the way to get there. And this is when the first spouse dies, you want the surviving spouse to own all of the assets. You don't want to leave a bunch of assets to the kids until you both die. If you want that, but you don't want the surviving spouse to be taxed on all of the assets that the surviving spouse holds at date of death, a trust is the best way to set that up. Now, it's not the only way, okay? And you may want to give a bunch of money to your kids before you're both dead. That's another good way of dealing with the estate tax. But if you don't want to do that, if you want to keep whatever assets you have until you're both deceased, but you don't want to pay tax on all of those assets, you need specialized estate planning, and a trust is the best tool to get there.
So
that's the best way to explain it.
Can the trust wipe out the need for estate tax for the surviving spouse and then later for the kids?
There's no estate tax paid by the surviving spouse unless it's very unusual circumstances. It's a tax when you both die. Unless you're like mega rich and you're using some very high priced fancy lawyers and it's intentional, you're not going to pay estate tax when the first spouse dies. It's a tax on the estate of the surviving spouse. So it's not an issue on the first death, it's an issue on the second death, and then that's how it works.
And then you're saying that for that situation, for the second death, the trust helps avoid estate tax on that.
That's right.
Is it avoid or is it reduce? I mean, does it
depends how much money you have. I mean, it's like the max you can avoid is 2 million. But you know, if you're rolling with a lot of dough, no. I mean, but you know, if you've got enough money, then you're going to hire lots of lawyers, and we're going to figure out, you know, the world's most good plan, so you don't pay a bunch of tax. There's a whole industry in that. It's not exactly what I do. I work way more with middle class people. But we have a guy in our firm that specializes in the 80 million and rolling crowd. So hell, we're here to set you up no matter what. But that's not really what I do.
Garvin, this was very informative today. You did an outstanding job giving us an overview of this complex area. You explained things very well.
I appreciate it. Thank you, humanists. So long. We
do have a token of our appreciation that we give to all our speakers. Our president, Dave DiNucci, can normally model that for us. Dave, do you have that ready today?
Yeah, I think you're talking about this, our
humanist mug.
And if you can't use it, maybe a friend can or something, but I've been using it all day and it's working great. So
that's wonderful. Thank you. Bye, everybody.
Thank you, Garvin. Enjoy your day.